You're matching a description, hands on the hood.
I'm not consenting to any search. I'm just unloading groceries, that's all.
I told you to turn around.
And I'm telling you I'm within my rights.
A 45-year-old cop saw a young black man standing behind a white SUV in a hoodie and decided he was a criminal. The man was a judge. The cop's body camera was recording, and that one decision cost the officer 20 years of his freedom and the city $500,000. Before we continue, let us know where you're watching from. Drop your city or country in the comments, and don't forget to subscribe and like the video if you're watching this for the first time. Judge Clarence Obie was 30 years old, youngest sitting judge in Delwood County. He had passed the bar at 24, clerked for a federal appellate court at 26, and been appointed to the bench at 29. People who knew him said he was the kind of person who never wasted a sentence, in court or out of it. Precise, measured, someone who had read the law so deeply that it had become the way he thought about everything. On this particular Saturday afternoon, he had just returned from his younger brother's college orientation. No suit, no title visible, just a young black man in an ash hoodie, dark jeans, and clean white sneakers, standing behind his white SUV at the edge of his driveway, pulling a duffel bag from the trunk. It was the kind of moment that shouldn't matter. For most people, it doesn't. Officer Brett Kowalski was 45 years old and had been with the Delwood City Police Department for 19 years. He was not someone his colleagues openly criticized, but he was someone they quietly noticed. Over the years, 3 informal complaints had been filed against him by black residents, each one citing unnecessary stops, aggressive language, and treatment that felt targeted. None of those complaints resulted in formal discipline. The department had looked at them, filed them, and moved on. Kowalski had learned where the line was, and he had learned how to stay just close enough to it without crossing it in any way that could be proven. Until this Saturday. He was running a routine patrol through the Aldenmore district when he came down Obie's street and saw the white SUV. He saw the young black man behind it. He slowed his cruiser. He didn't keep going. He pulled to the curb, stepped out, and walked toward Clarence Obie with deliberate, unhurried steps, one hand loose near his belt. "Hey, don't move. Stay right there." Obie looked up. He didn't reach for anything. He didn't step back. He stood still, both hands resting on the edge of the open trunk, and waited. Kowalski told him there had been a report of a stolen white SUV in the area. That was the reason he gave. He asked Obie to step away from the vehicle and keep his hands visible. Obie stepped to the side, hands up, open, visible. He said, "This is my vehicle. This is my residence. I just returned from dropping my brother at orientation." Kowalski didn't respond to that. He asked for ID. Obie told him his wallet was inside the house and offered to go get it. Kowalski told him not to move. Then he told him to get on the ground. And this is the moment, because most people, when a police officer tells them to get on the ground, do it. Not because it's right, but because the alternative feels too dangerous to consider. Clarence Obie understood that calculation better than most. He had seen what happened when people didn't comply. He had read the case law. He had ruled on it. But he had also read something else. Every statute, every precedent, every constitutional guardrail that existed specifically to prevent what was happening to him right now, and he was not going to pretend he hadn't. He looked at Kowalski and said, "I won't be getting on the ground. You don't have reasonable articulable suspicion to detain me based on a general report of a stolen SUV in the area. That doesn't meet the standard established in Terry versus Ohio, and I think you know that." Kowalski told him to stop talking. "I'm not going to stop talking," Obie said. "You haven't witnessed a crime. You haven't confirmed this vehicle matches any stolen vehicle report. You haven't run the plates. You have no probable cause for detention, and you have no grounds for arrest. If you touch me without legal justification, you are committing a violation of my civil rights under 42 U.S.C. Section 1983. I want that stated clearly for your body camera." The Axon camera on Kowalski's chest was recording. It had been recording from the moment he stepped out of the cruiser. Every word Obie said was going in. Every word Kowalski said was going in. The timestamp was running. Kowalski looked at him, this young man in a hoodie who was standing in his own driveway quoting federal statutes, and something moved across his face. It wasn't confusion. It wasn't reconsideration. It was something that looked a lot like decision. He told Obi he was being detained for suspicious behavior, and that if he didn't cooperate fully, he would be placed under arrest. Obi looked directly at the lens of the body camera and said, "I am cooperating with every lawful instruction. What is being asked of me right now is not lawful. I want that on the record."
Kowalski's next move was not to run the plates. It was not to verify the stolen vehicle report. It was not to ask a single follow-up question that might have resolved everything in under 2 minutes. His next move was to call for backup. While they waited, he told Obi to stop citing laws at him. Obi said, "I'm not citing laws at you. I'm informing you of your legal obligations and mine. There's a difference." Kowalski stepped closer. He said he didn't care how educated Obi thought he was. He said out here, on this street, the only thing that mattered was that he had reasonable suspicion and Obi was going to comply or face consequences. Obi didn't flinch. Reasonable suspicion requires specific, articulable facts. A hoodie and a white SUV in a neighborhood where a white SUV was reportedly stolen does not meet that threshold. You need more than proximity to a general description. That is not my opinion, that is settled law. Kowalski told him to put his hands behind his back. Obi kept his hands visible and said, "You have not told me I'm under arrest. You have not stated a charge. You cannot lawfully restrain me without one." A woman named Patrice Holt had stepped onto her porch across the street. She was 58 years old, a retired school administrator who had lived on that block for 21 years. She had seen Judge Obi move into the neighborhood 8 months earlier. She had spoken to him twice, once when he helped her carry groceries, once when she saw him leave for work in his court attire. She knew exactly who he was, and she knew exactly what she was watching. She went inside, came back with her phone, and started recording. 2 patrol units arrived within 5 minutes. Officers Senakwashi and Paul Deddy stepped out and approached. They had been told, possible stolen vehicle, uncooperative subject. What they found was a composed young black man standing with his hands open at his sides and Brett Kowalski standing close, rigid, breathing through his nose. Deddy, without a word to Kowalski, walked to the rear of the SUV and ran the plate on his radio. 58 seconds later it came back. Registered, no flags, owner listed as Clarence A. Obi, address, the house directly behind them. Deddy looked at Kwashi. Neither of them said anything immediately. But Kowalski wasn't looking at them. He was still looking at Obi. Obi turned slightly toward Deddy. "I'm assuming the plate returned clean and registered to this address." Deddy said, "It did." Obi nodded. "Then the original basis for this stop no longer exists. Continued detention beyond this point is unlawful. I'd like to be free to go." Kowalski told Deddy to stay out of it. That exchange, Deddy confirming the plate, Kowalski dismissing it, was captured on both their body cameras, simultaneously, time-stamped, stored. And still, Kowalski reached for his handcuffs. He told Clarence Obi he was being placed under arrest for obstruction of a police officer and failure to comply with lawful orders. Obi placed his hands behind his back without being told twice. He did not pull away, he did not raise his voice. He said, clearly for both cameras, "I am not resisting. I am complying under protest. This arrest has no lawful basis. I am a sitting judge in this county, and I will be pursuing every legal remedy available to me. I want all of that on the record." Kowalski cuffed him and walked him to the patrol unit. Kwashi stood by the SUV and said nothing. Deddy stood near his cruiser and said nothing. Patrice Holt across the street kept her phone up and kept recording. Inside the patrol unit, Kowalski sat in the front and began filling out his report. He wrote that the subject had been verbally combative, had refused repeated lawful instructions, and had made statements that the officer interpreted as threatening. Not one word of that was true, and there were now 3 camera recordings and 1 civilian video that were going to prove it. Clarence Obi sat in the back of that patrol unit for 34 minutes. Hands cuffed behind his back, ash hoodie, jeans, white sneakers, watching through the window as Kowalski stood outside talking to Kwashi and Deddy like nothing unusual had happened. He didn't panic. He didn't cry. He sat straight and thought through every step of what came next, because he had been on the other side of situations like this. He had read the police reports. He had reviewed the body cam footage. He had ruled on the cases.
and he knew with absolute certainty that everything he needed was already recorded. At the station, Obi was processed. Fingerprints, photo, the full procedure. The desk officer, a younger man named Toby Reeves, looked at the name on the paperwork and went still for a moment. He looked up at Obi, then back at the paperwork. He said quietly, "Are you Judge Obi from the county court?" Obi said, "I am." Reeves looked at Kowalski. Kowalski told him to finish processing. Reeves finished processing, but before the end of his shift that evening, he walked to the watch commander's office and said he thought someone needed to look at what had come in that afternoon. The watch commander was a woman named Lieutenant Ava Sims. She pulled up the body cam footage from Kowalski's unit before she went home that night. She watched it once, then she watched it again, then she picked up her phone and called the department's legal liaison. She didn't sleep well that night. By Sunday morning, 3 things had happened simultaneously. Patrice Holt had posted her phone footage online. It had been shared 400 times before noon. A legal affairs journalist who covered the county courts had seen it, recognized Judge Obi's name in the caption, and made 3 phone calls. And the Delwood County Court Administrator had contacted the presiding chief judge to inform him that one of his judges had been arrested the previous afternoon. The story moved fast. By Sunday evening, it had crossed local news. By Monday morning, it was national. Inside the department, Lieutenant Sims had already escalated to the chief. The chief had already contacted Internal Affairs, and Internal Affairs had already submitted a formal request to preserve all body cam footage, dispatch records, and written reports from the incident. When investigators pulled Kowalski's report and placed it beside the body cam footage, the contradictions were immediate and significant. He had written that Obi was verbally combative. The footage showed a man who never once raised his voice. He had written that Obi refused repeated lawful instructions. The footage showed an officer who never once stated a lawful basis for his instructions. He had written that Obi made statements the officer interpreted as threatening. The footage showed a man quoting constitutional law calmly with his hands visible. Then Internal Affairs pulled Kowalski's full service record. The 3 informal complaints from black residents, a use of force incident in 2019 that had been reviewed and closed without findings, a supervisor note from 2021 that described Kowalski as someone who, quote, sometimes allows personal assumptions to influence initial contact decisions. That note had been filed, never acted on. What the record showed, taken together, was not a single bad day. It was a pattern. 19 years of a pattern that the department had seen, documented in pieces, and never fully confronted. Kowalski was placed on administrative leave pending investigation by Monday afternoon. He was told to surrender his badge and his weapon. He told his union representative the whole thing was being blown out of proportion. He said Obi had been uncooperative and that he had done everything by the book. The union representative had watched the footage by then. He didn't say much in response. Across town, Clarence Obi had been released Sunday morning after the department quietly dropped all charges. No formal apology, no phone call from the chief, just a call from the legal liaison informing him that the charges had been dismissed and that the department would be in touch. Obi thanked the liaison, ended the call, and immediately contacted his attorney.
Clarence Obi's attorney was a woman named Falake Adeyemi. She was 44 years old, a civil rights litigator with 17 years of experience and a reputation for being methodical in a way that made opposing counsel uncomfortable. She didn't grandstand. She didn't give long press statements. She built cases the way an architect builds structures, carefully, load-bearing, designed to last. When Obi walked into her office on Monday morning and placed a written timeline of the entire incident on her desk, she read it without interrupting him. When he finished, she looked up and said, "How many cameras were on you?" He said, "At least 3, possibly 4 with the civilian recording." She said, "Good. We're filing." The civil suit was filed against Brett Kowalski personally and against the city of Delwood on Tuesday. The claims included unlawful arrest, false imprisonment, violation of Fourth Amendment rights, violation of 14th Amendment equal protection rights, and civil rights violations under 42 U.S.C. Section 1983. The exact statute Obie had cited in his own driveway while Kowalski was putting handcuffs on him. The city's legal team received the filing and immediately requested a private meeting with Adeyemi. She agreed to the meeting and brought Obie with her. The city's lead counsel opened by suggesting that the incident was an unfortunate misunderstanding and that the department had already taken corrective action by placing Kowalski on leave. Adeyemi put 3 things on the table: the body cam footage, the internal affairs report detailing Kowalski's service record, and the supervisor's note from 2021 describing his pattern of assumption-based contacts. She said, "This was not a misunderstanding. This was the foreseeable result of a pattern your department identified, documented, and chose not to address. That makes the city directly liable." The city's council asked for 2 weeks to consult internally. Adeyemi said they had 1. Meanwhile, the criminal side of things had begun moving on its own track. The district attorney's office had been watching the footage and reviewing the internal affairs findings. What concerned them most was not just the arrest itself, but Kowalski's written report. A police report that directly contradicted documented body cam footage was not a mistake, it was a false official document. And filing a false official document to justify an unlawful arrest carried its own set of charges entirely. The DA assigned the case to a senior prosecutor named Victor Stein. Stein spent 4 days reviewing everything: the footage, the report, the service record, the civilian video, the dispatch logs, and the statements from officers Quarshi and Deddy. Both Quarshi and Deddy had by this point given full cooperative statements to Internal Affairs. Deddy confirmed that he had run the plates, confirmed the vehicle was clean, and confirmed that Kowalski had been informed of this before making the arrest. Quarshi confirmed the same. Kowalski, on the advice of his union representative, had declined to give a statement. Stein presented his findings to the DA on a Friday afternoon. The DA reviewed them over the weekend. On Monday, she authorized charges. Brett Kowalski was charged with unlawful arrest, filing a false police report, deprivation of rights under color of law, and misconduct in office. He was taken into custody on a Tuesday morning, 19 days after he had put handcuffs on a judge in that man's own driveway. His attorney entered a not guilty plea. The union initially pledged support for his defense, but within a week, as the footage continued circulating and the department's own internal records became part of the public record through the civil proceedings, the union quietly reduced its involvement. They stopped returning Kowalski's attorney's calls with the same urgency. The case had become something they didn't want attached to their name. The trial took 4 months to reach conclusion. The prosecution played the body cam footage in full for the jury. They played Patrice Holt's phone video. They read Kowalski's written report aloud and then played the corresponding timestamp on the footage for every claim he had made. Combative. The footage showed calm. Refused lawful orders. The footage showed a man with his hands up asking for a legal basis. Threatening statements. The footage showed constitutional citations spoken evenly to a camera. Kowalski took the stand in his own defense. His attorney walked him through his reasoning, the stolen vehicle report, the suspicious behavior, the escalating situation. He said that he had felt threatened. He said that Obie's knowledge of the law had felt aggressive to him. The prosecutor, on cross-examination, asked him one question that the courtroom remembered afterward. She said, "Officer Kowalski, in 19 years of service, had you ever arrested someone for knowing?"
The jury deliberated for 11 hours across 2 days. On the morning of the 3rd day, they returned to the courtroom and delivered their verdict on all 4 counts. Guilty, 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 guilty. Brett Kowalski stood at the defense table in a gray suit and received each one without visible reaction. His attorney placed a hand briefly on his arm. Kowalski didn't move. Sentencing came 6 weeks later. The judge presiding over the case was a 61-year-old woman named Judge Patricia Mensah. She had served on the criminal bench for 14 years. She was known for measured, thorough sentencing decisions that she always explained in full, out loud, in open court. She looked at Kowalski for a long moment before she spoke. She said the court had considered his 19 years of service. She said the court had considered his lack of prior criminal convictions. She said the court had also considered the body cam footage, the false report, the service record, the pattern it revealed, and the fact that he had chosen, at every single decision point on that Saturday afternoon, to escalate rather than verify. She said the court had considered that a man had been handcuffed in his own driveway, processed through a police station, held overnight, and publicly identified as a criminal, and that all of it had been built on nothing except an assumption. She sentenced Brett Kowalski to 20 years in state prison. His attorney immediately announced plans to appeal. The appeal was filed. It was reviewed. It was denied. The conviction and sentence stood. On the civil side, Folake Adeyemi had continued building. The city's legal team had come back after their week with a settlement figure. Adeyemi had declined it. They came back with a higher one. She declined that too. She told them her client was not interested in a quiet resolution that allowed the city to avoid public accountability. She wanted the findings, the service record, the supervisor's note, the pattern of complaints entered into the public record as part of any resolution. The city resisted that for 2 months. Then they looked at the trajectory of the case, looked at the footage that was still circulating, looked at what a public trial would cost them in every sense, and agreed. The city of Delwood paid Clarence Obie $500,000 in damages. The settlement agreement included a requirement that the department implement mandatory retraining on lawful detention standards, that all informal complaints be reviewed and formally documented going forward, and that the supervisory note on Kowalski's record be used as a case study in new officer training. None of that brought back the night Obie spent in a cell. None of it erased the footage of him in handcuffs that had traveled across the internet before anyone had even asked whether the arrest was legal. None of it touched the particular kind of exhaustion that comes from having to fight with citations and statutes and attorneys and courtrooms for something as basic as the right to stand in your own driveway. But it was accountability, real, documented, structural accountability. And in cases like this, that is not a small thing. Clarence Obie returned to his courtroom 3 weeks after the criminal verdict. He walked in wearing his robe, took his seat at the bench, and called the first case of the morning. The attorneys in the room that day said he was exactly the same as he had always been, precise, measured, focused entirely on what the law said and what fairness required. He gave one statement to the press through Adeyemi's office after the civil settlement was finalized. It was 4 sentences long. He said that he had not been treated that way because he was a judge. He had been treated that way because of what he looked like. The title and the robe were in his closet that afternoon. What was standing in that driveway was just a young black man in a hoodie, and that should have been enough. Patrice Holt, the neighbor who had recorded everything from her porch, was asked by a local journalist what she thought when she saw the verdict. She said she was glad. Then she said she was tired. Then she said both of those things were true at the same time, and she didn't think she needed to choose between them. Officer Deddy quietly requested a transfer to a different district 4 months after the trial. Officer Quarshi was commended internally for his cooperation with the investigation. Desk Officer Toby Reeves, the young man who had recognized Obie's name during processing and walked to the watch commander's office, was later cited in the department's internal review as the first person in the chain who had done exactly what he was supposed to do. Brett Kowalski began serving his sentence at a state correctional facility 80 miles from Delwood. He was 45 years old, the same age he had been on that Saturday afternoon when he pulled his cruiser to the curb and decided a young man in an ash hoodie standing behind his own car was worth stopping. A 30-year-old judge, his own driveway, a hoodie and jeans, a body camera that recorded everything, and a system that for once actually followed the evidence where it led. The question is not whether justice was served in a courtroom. It was. The question is what happens in all the cases where there is no body camera, no neighbor on the porch, no retired school administrator with a phone and 19 years of knowing who their neighbors are.
What happens when the footage doesn't exist and the name on the report means nothing to the desk officer processing it? That is the question this story doesn't answer, because no verdict does. If this story made you think, drop your thoughts in the comments below. Do you think 20 years was the right sentence? Would you have handled any moment of this differently? Let us know. And if you're new here, please like this video and subscribe. Stories like this one are why this channel exists.